All right. Well, hello, everybody. We probably still have some people signing in, so we'll just give them a minute. And I do notice that some of the participants have their profile off, and that's okay. I think regardless of whether you show or not on the participant list, if you even have it on your screen, you can still raise your hand at the bottom. Um, if you have any questions or you want to participate, and we can communicate that way. So, with that being said, for people who don't know, I'm Eric Alderson. This is Jen Costanzo. We're with Promark Partners Insurance Services. We're your risk managers. Um, and the purpose of these webinars and these events is to, number one, provide hopefully some valuable training, um, to allow all of our clients who, sometimes it's difficult, especially as we're growing and you're growing and uh, all of that, to get out and see everybody on a regular basis to do risk management training. So this is a good way for you guys to fill that credit and make sure that we can put that on the application and max out the risk management credits that are available for professional liability. Um, and we're not technical experts, Jen and I. We are insurance people. So this format is somewhat new to us, so bear with us. We're going to try and do the best we can. But again, like I said, we do like to keep, just like we do any other seminar or webinar that we do, kind of an open forum. So please feel free, raise your hand, interact if you have something that you want to interject or you have a question. We're happy to address that. So without further ado, I will share my screen and hopefully this works. It looks like it did. Um, so today's topic, again, this is the first in our live webinar series. We're going to go through on a monthly basis all of our programs, and we might change things up a little bit here and there, depending on whether or not there are pertinent topics that we want to talk about that are outside of the program schedule. Um, we may invite some guests and other experts to join us on the panel for other discussions as well. So hopefully everybody finds it interesting and useful. Again,
No,
sorry.
I was just gonna say, if you are joining us, we may not know who is in the audience, and we may not know it. You may have a whole room full of folks. So if you would just shoot Eric or I an email, shoot me or Eric an email, and let us know who was there. And if you have an AIA number, please let us know that, and we'll report it to AIA. If you want a certificate of completion to proudly hang up in your office or your cubicle, let us know, and we're happy to send that as well.
I have all mine hanging. It's really
He
nice.
doesn't.
Okay, so today we're talking about principles of risk management. Today is an overview. We're going to introduce the idea of risk management. Again, we're AIA certified, so please send us your numbers if you'd like credit for it. So we're going to talk about basic risk management techniques, concepts. We're going to introduce that to everybody who this may be new for. For a lot of you, this is going to be review. Obviously, we're going to discuss liability of design professionals, where it comes from, how it's established. And then we're going to talk a little bit about insurance coverage, just to introduce the idea of how insurance relates to those duties, risks, and exposures, and how they function and what they cover. And then discuss, obviously, everybody's role in protecting the firm, whether that's us as your risk manager or principal, partner, owner, all the way to staff, designers, clerical, admin, personnel, all the way down the line.
All right, so when we talk about risk management, we've got several options, and this really is insurance or risk management 101. So you can retain a risk, meaning you can hold on to it, avoid it altogether, which is nearly impossible when you are in a business environment. There are always going to be risks, and you can't just lock yourself away. So you can avoid them where you can. If they're particularly egregious, you might want to mitigate or lessen, allocate, and identify a party that should have control or take on that responsibility for that risk, and transfer. So transfer of responsibility in the insurance world is the transfer of responsibility for a liability to an insurance company. That insurance policy is a contract between you and the insurance company in exchange for premium. So you transfer your liability to an insurance company by that method. You can also transfer your risk, or your clients can transfer their risk to you through a contract. So we have contractual transfers, we have transfer of risk through different methods. Is there someone have a question?
Nope.
Nope. Oh, okay. Sorry about that. So anyway, these are the things that we are going to focus on. And in any situation that you have when you're deciding to bring on a project, when you're reviewing a contract, when you're going through and identifying the scope of the risk that you have, you will likely go through all of these things. So the negotiation, the decision to take on the project, and then how to manage it throughout. You're going to go through all of these. When we talk about responsibility, we're talking about how the law views you in two different ways. We're talking about tort law and contract law. We're not going to talk about criminal. We're going to assume that no one is going to step into that field, although we've had our fair share of that with folks at times. And the law recognizes that you're different. As such, there is the negligence standard. So how you respond to something should be in the way that another reasonable person, prudent person, design professional would respond in the same similar fashion. So you have the negligence standard, and then you have contract law. You can assume obligations that are outside of what tort law says you are responsible for. Common law says you're responsible for X. Contract law, you can launch yourself outside of those responsibilities, and you can change or exceed your legal expectations.
Okay. Just trying to keep up with the Q&A here.
Oh, okay.
So,
Anything we need to stop and
nope,
talk
not
about?
yet.
Okay,
Yeah.
sounds good. So when we talk about a tort, we're talking about these four elements which must be met. So there has to be a duty to perform, a breach of that duty, and that breach of that duty must cause damages. If one of the elements there isn't met, if you don't have one of those elements there, it's not negligence. So easy example, because this is New York, and so we get lots of snow. I live in the city of Buffalo. As a homeowner, I have a responsibility to clear my walkway, my path for folks coming up and down, visitors, etc. If I don't clear my sidewalk of ice and snow, and someone walks down the sidewalk and they fall and they break their arm, I'm responsible. I have been negligent, with some variation, but I've been negligent here. I had a responsibility to clear my walkway of ice and snow. I didn't. Someone was hurt. They have damages. My failure to clear the ice and snow is the causation of those damages. So I am negligent. I am responsible. However, flip that around. If I have a responsibility to clear the ice and snow from my driveway and my neighbor looks out the window and he's just aggravated because I haven't done it yet, that's not a tort. I have not been negligent. No one was hurt, maybe his feelings, but there are no damages resulting from my lack of duty in that situation.
So one question we get a lot is, that's great. How does this relate to design services? What would be a real world example of something that might happen during the course of a construction project?
Sure. So one we see very often is when there is an omission. And so one case that I can think of right off the top of my head was the failure to include handrails in a design. And that failure was found in time. So there are these handrails that need to be put in. The design is adjusted. There are no additional costs associated with putting in those handrails. Now, from the owner's point of view, they may think differently. They may say, well, you didn't include them. You made a mistake. You omitted them. Therefore, I want you to pay for them. Well, it's not really negligence. Even though you made a mistake, it didn't rise to the level of negligence because there were no damages. The owner would have been responsible otherwise to pay for those handrails. Asking you to pay for those handrails is actually a betterment in that situation and not allowable. So that's one very quick example of how that plays out. And one of the reasons, if you're familiar with our contract reviews, that we keep going back to this might not rise to the level of negligence, because you can make mistakes, you can have omissions, It doesn't mean that you've actually had negligence in the performance of professional services.
Yeah, and it's interesting to talk about too, because we have seen an uptick in mostly, I think colleges and universities are doing it, but state agencies are, kind of reviewing that list of errors and omissions from prior projects,
Mhm.
right? And trying to, and I think they've gotten better recently of trying to categorize them appropriately for negligence-based errors and omissions versus those non-negligence based errors and omissions. And it took a little bit of time to get to that point where I think there was a good understanding of the fact that not every error, not every omission rises to that level because you have to have all of these elements. And that's not always the case.
Exactly. So I think we said this a little while ago, the common law standard of care. If you were with us today, we might canvass the audience and ask, do you know what the common law standard of care is? And I'm always a little surprised at the answers that we get. We've actually gotten answers like to be the best or to do our best job, or, that's not actually the case. Your common law standard of care is just a duty to exercise the degree of learning and skill ordinarily possessed by a reputable design professional practicing in a same or similar situation. So it's that reasonable person's doctrine. You want to do the same thing that another reasonable person would do in a same or similar situation.
And it's meant to be a moving target, right? It's not
Absolutely.
as finite as I think a lot of people will sometimes try and make it more finite than it really is. It's a moving target. It's meant to be that way. You want it to be that way. So when you see it be a little bit more static, and we see everybody's contracts all the time, and we see some pretty wacky standards of care that it definitely rise beyond the level that it should. But this is a good common law standard. There are variations to this. I actually like the AIA language a little bit better than the EJCDC language for it, because I think it goes one step further and talks about uh, you know uh, disclaiming warranties and guarantees as part of it too. But as a basis for it in common law, this is a good example of a standard of care.
Yeah. And a breach of contract there is obviously not a tort. So it's an act of breaking the terms of a contract. So not a legal obligation. When we talk about breach of contract, we're talking about something that is outside of what your normal legal responsibility is. So if you, within a contract, agree to a standard of care to perform in a way that is similar to another reputable design professional, that language that we saw, or the AIA document, even though that language is in a contract, you have that responsibility with or without the contract. We're talking about the things that are otherwise not your responsibility. So a breach of contract obviously has to be contractual, has to be material and serious. If you call something aqua and somebody else calls it teal, that's not, unless it's specifically about colors, not material or serious, for instance. And then the way that you remedied this is through money restitution, uh, reformation, or performance. So, sorry, I have trouble reading a little bit. I'm getting old.
Closer.
Yeah, thank you. So those are the remedies for a breach of contract. We're making this distinction for a reason. So just bear with us for a second here. Your legal duties, codes and standards, registration laws, rules, regulations, licensure responsibilities. Those are your legal requirements. And those are how your duties are established in identifying how you should perform your services. So if you are uh, designing a building in Texas, right, you're not going to use the codes or the standards that apply for Syracuse, New York, that kind of thing. So you're going to perform in a way, these are your legal duties and all of those things, registration, rules, regs, other laws.
And your legal duties as design professionals is different than those of
A
a
contract,
contractor or
a lawyer.
medical professional. Yeah, and so their codes and standards, their registration laws, licensure, all dictates how they're required by law to perform their services. So it's specific to each profession.
Absolutely. So here's a reason why we talk so much about tort liability, what your legal requirements are against contractual liability. Very simply because we want you to have coverage in the event that something goes wrong. So if we're reviewing a contract for you, we're gonna be identifying those things that are increased risk and maybe outside the scope and the coverage of your professional liability policy or any of your policies, but mostly it's professional liability. Professional liability policy is designed around your tort liability, around your legal requirements. And it excludes specifically contractual obligations unless they're otherwise covered. And I know that sounds like double speak, but really what that means is, again, you can agree contractually to perform to the standard of care. You would have that anyway. It's the other stuff. So if someone comes back and says you breached the contract because you did not perform to the standard of care, that's not really a breach of contract. That's a tort. That's
Breach of your
negligence.
tort. Yeah, so that's an important distinction because I think a lot of our clients kind of get wrapped up in that idea of, you know, breach of contract is not okay in a contract, and so we have to get that out of there. We have to remove it, and um, it has to be looked at holistically. You can agree to say indemnify another party for breach of contract as long as all of the terms in that contract are insurable and otherwise um, part of tort liability and not something that extends beyond that into contract liability or contractual liability. And then your breach of contract is fine. But you get into trouble when you contractually obligate yourself to indemnify for a breach of contract when there are other provisions in that contract that might not be part of your tort liability and not otherwise covered by insurance. So it's really kind of a circular argument in some cases. And so you do have to look at those things holistically. But that's the key takeaway here is your insurance policy is only going to cover you for those things that are born out of tort liability. And any extension beyond that um, could be could be an uncoverable claim.
So let's just give a couple of examples of that, because it just sounds like we're kind of spinning up here academically about what you're responsible for. So some quick things would include obligations, for instance, to pay for the defense costs, whether or not you are responsible, whether or not that's part of damages. That is a contractual obligation that's outside the scope of your coverage. Professional liability policies are policies of indemnity. So when you indemnify another party, you make them whole, you pay them back for the damages that they suffered because of your negligence. That's what the policy is crafted around. But if you agree contractually to pay prior to a determination of negligence, whether or not there's negligence, including costs, allowing them to choose the attorney, allowing them to choose whomever they want, and allowing them to run with it whenever, you are obligating yourself to something that is contractual and not legal. The policy is not going to cover that. They're not going to cover those costs. They may, if it's part of damages, if, the award that's given to that, the opposing party, if they're given defense costs and it's part of damages that might be included, that's very different than having an obligation to pay for a defense cost ahead of time. Or an obligation to, perform to the highest standard or to have perfect specs.
I was going to ask you if I don't think we talk about elevated standard of
We
care
don't, not in this one.
in this one.
Not
Yeah.
in this one.
But that's between indemnity provisions and elevated standards of care is probably where we see the most um, contractual liability come into play. So those obligations that are greater than your tort liability. So
Warranties and guarantees, that are outside of what you would otherwise be responsible for. Again, standard of care. You can guarantee that you'll perform to the standard of care because you're responsible to do so anyway, but you can't guarantee that something is going to meet a lead standard, for instance, right? That it's going to be, silver, and that there are going to be cost savings based upon the,
Yeah.
The level that's achieved.
You can't guarantee that your plans and specs will fully conform with codes, laws, requirements. Obviously, that's the goal and that's what we're trying to do. But that has to be tied back to the standard of care because sometimes there are conflicting codes and it requires a little bit of interpretation. So those strict conformance provisions in a contract can elevate your standard of care beyond your tort liability standard or your common law standard that we talked about before.
Yeah, and the goal always is to make sure that we're giving you information on those contracts when we're doing those reviews, if you've seen our reviews, or if you're looking at a contract yourself to say, hey, would I be responsible for this if there was no contract? You would have an indemnity responsibility. That's just a common law. You have a responsibility to perform to the standard of care. You have a responsibility, according to the standard of care, to design two codes and standards. Understanding that there could be conflicts, you have to use your professional knowledge to decide which applies. There are a lot of things that should be standalone outside of the contract. That's what we're looking for. So I promise you, when we're reviewing, we're not trying to be a pain and just make it more difficult for you to negotiate. We're trying to make sure that you're not outside of your insurance coverage. That's not only professional liability. We don't really talk about the other lines of business, but that's for all lines. So if you're being required to provide insurance for something for which you really don't have an exposure, or you shouldn't have an exposure, we're going to do the same thing. That would be like transportation of pollutants. Why would you ever be transporting pollutants? Shouldn't be obligated to provide coverage or have a responsibility for that, for
Right.
instance.
So we'll talk a little bit about, we're going to focus mostly, like Jen said, on the professional liability coverage itself, but we are going to touch a little bit on the other lines because I do think they're important to discuss. But your professional liability policy is really intended to be a third-party liability policy. And that's the purpose of it, is to um, reimburse or indemnify another a third party for damages that are caused by your negligent performance of services. But it also provides what we call first party coverage in the form of defense. So when you are brought into a suit, you're named, there's a situation where you're unsure of whether or not it's going to turn into a lawsuit or a full-blown claim. The policy does provide that first party coverage to defend you against those allegations. There's other supplemental coverages as a part of it. We only have a few listed here. Um, Disciplinary regulatory proceedings, if you're required to attend a proceeding that maybe somebody alleges that you violated your licensure. You have coverage for attending those things on a per
Very
day
limited.
basis. It's not very much. Defendant reimbursement coverage, same thing. If you're required to testify, go to uh, deposition
Oh, yeah.
at the
Sorry.
request of the insurance company, you will be reimbursed for those things, and crisis event coverage for situations where, and we've actually had this happen a few times, where a claim is so bad or so public um, that there's news about it in the paper or on TV, and it just becomes public knowledge. And to mitigate whatever negative impact it might have on the firm, the insurance company will retain a PR firm to help lessen the effects of that, or help guide you through that process. And so there are other supplemental coverages that we don't talk about here. Pre-claims assistance obviously is the one that we talk about the most, I think. And I
I
think
think
we'll
that's in
we'll
there.
get to that. Um, but this is an example of a pretty standard insuring agreement on the professional liability policy. I think the big takeaway here is your uh, negligent act, error, or omission in rendering or failure to render your professional services. Anytime you see a bold term in an insurance policy, it means it's a defined term. So these are things that we look for when we're helping guide you through that process. Is how broad is that definition of professional services? What does that encompass? What does it mean? And so we go through a few of the definitions of the policy that we think are obviously the most important ones in claim. We have to know how the policy defines a claim and what that means. And this is unfortunately kind of a big misconception in the world of policyholders, is where do we draw that line, or where do we go from, hey, there's this thing going on, to, oh my God, we have a claim. And I think a lot of people tend to think that it's when that service of suit is brought to you, when that document is delivered to your office or sent to your staff. That's when you have a claim. And the reality is most policies will define it just like this. It's a demand um, for money or services, and it alleges a wrongful act. And that can be pretty broad. That can be something that happens in a meeting. That could be something that happens on a phone conversation. It could be email exchanges, um, where somebody says, "Hey, this is going on. This is wrong, and you're going to fix it." Well, now you've got a claim on your hands.
Right, so I'm gonna give you, I'm gonna give you guys an example of this, and I wanna say that when it happened to this client, it was prior to them being a client of ours. So, principal is in a meeting, with the whole team. So you've got, the design team, the contractor, the CM, the owner, and the owner is mad, and the owner says, there's a problem and one of you is going to fix it. He's just very aggravated. There's water coming in, infiltration into, the first floor, and he wants it fixed. So fast forward 2 years, and now this client is a client of ours. We've moved the insurance. We've asked all the questions about knowledge of prior claims, knowledge of prior incidents, so that we can move forward. And he tells us no. Formal claim comes in as a service of suit. And during the investigation, the claims adjuster finds out that that principal was in that meeting where that owner demanded that it be taken care of. A demand for money or services, as a matter of right is the definition in this particular policy, but a claim of wrongful services. So it was determined that this principal actually had knowledge well before that suit came in. When we asked him why he didn't put the prior carrier on notice when that happened, or why he didn't identify it as an incident or a claim, was because he spoke to his broker and the broker told him it wasn't a big deal. And it was a very big deal. So there are, plenty of folks, insurance people included, who don't understand the ramification of this. So it is a demand, and it doesn't need to be in writing, and it doesn't need to be a service of a suit. It's a demand for money or services alleging a wrongful act by you. And that's all it needs to be. So if you have a situation like this, the reason why we harp on this is to make everyone very sensitive to this. If it feels a little awkward, if it feels a little off, if it feels a little funny, talk to somebody, talk to us. Let us determine whether or not it's an actual claim, or if it is in fact a circumstance that should also be reported. And I will say this as well. There have been plenty of situations where we've had a circumstance, which means that it hasn't gotten to that full demand, you did something wrong, hasn't gotten through that. It just says somebody did something wrong. We're not sure who did it wrong yet, but somebody did something wrong. That's that kind of circumstance situation where you haven't been blamed yet, but it could come at you.
Yeah.
So in those situations, the minute that somebody says, I want money or I want services, that changes into a claim. The demand for money, the demand for services, oftentimes will take a circumstance or an incident report into a full-blown claim. So that's another distinction there.
Yeah, I think we get into that in a little more detail here,
Yep.
and but that's why we want to be sensitive to it, and that's why a lot of these policies are what's called circumstance reporting policies, is to give you that ability to not have to worry about determining that on your own.
Yes.
It gives you that ability during that gray area where something really isn't right and you're not sure of what to do. Um, you just report it as a pre-claim and or an incident or circumstance. It's all used kind of interchangeably, depending on the carrier, and we just kind of put a pin in that. We'll talk more about that in a minute. Another key definition is insured. Obviously, it's important to know who's insured under the policy. Every policy is a little bit different. So this is just an example of one of them, and like I said, some lay it out a little bit differently, but this is an important thing to understand in your insurance policy. The scope of coverage and who's covered under the policy is important to know.
Key here is identifying in your own policy whether or not predecessor firms are included as an insured. Predecessor firms in some policies are automatically included if you have responsibility for them. So if it was an asset only purchase, for instance, right, you don't really have a past responsibility for that firm. You may have ongoing, but you wouldn't have past. But if you purchased the assets and the liabilities, for instance, of a firm, they are a predecessor firm. Some policies will include it automatically.
Mhm.
Some require that they are fully listed as predecessor firms within the policy. So we, as a matter of course, in our application, ask for those lists always, because we want the ability to go with any carrier that requires the listing or doesn't, and have that listed there so that we are covered on both sides. But those are important and key in the event that you ever decided to have an insurance policy that wasn't with us, or for the prospects that are on the phone that are with us right now.
Yeah, and I do think pointing out items 3 and 7 on this list are important too, because most policies will include coverage for former retired principals while they were acting in the capacity of that role within the firm. So it's that prior acts coverage for things that might name those retired principals for projects that they worked on while they were in that role with the firm. But item 7 extends that to former principals, retired officers, directors, partners, members that are acting in the capacity as a consultant. We do see that a lot where retired principals will still consult to the firm. They're not always covered. The coverage is not always extended to those services of the retired principal. So that's an important distinction too. So if you have that situation, you're unsure, reach out to us, let us know. Usually the coverage is available. It's just not always automatic. So sometimes we just have to add an endorsement to it. Okay.
Okay.
Professional services, we talked about this a minute ago. I feel like this might be a little out of order, but broad definition of professional services in the policy is super important. We want to make sure that you're not only covered for the things that you do in your role on a project, but you're also covered for the vicarious liability of any consultants that you may hire as well. Often overlooked if you have a very limited professional liability policy that has a limited scope of professional services, it might only include that which you're uh, applying for in your application. So if you're an architect, it'll cover architectural services. But if you're an architect and you have to hire a consultant that performs engineering services or geotechnical services, um, you may not have the coverage for the vicarious liability that you inherit by virtue of hiring that consultant. So we want to make sure that it's very broad. This example that we have here is listing services, and I think the all-encompassing one is technical consultant. I think that kind of covers a lot of bases, and it's meant to be that way. Other policies will say anything for which you're legally qualified to perform, and that is obviously a more broad way of providing that coverage.
Here's that contractual liability exclusion. This is what it looks like. And of course, it does sound like a little bit of double speak, right? Shall not apply to the extent the insured would have been liable in the absence of such contract or agreement. And that goes back to that whole standard of care. Even if it's in the contract, it's not a breach of contract, you would have that responsibility. Otherwise, they will not invoke this contractual liability exclusion for those particular things.
And this is a good negotiating point. We actually use this to kind of help our clients negotiate their contracts because at the end of the day, if there is something in the contract that is beyond the scope of insurance coverage or it triggers this exclusion, it doesn't benefit anybody. Your clients are really looking to trigger your insurance coverage. They don't want your tables and chairs out of your office in the event of a loss. They want to make sure that the language in that contract triggers coverage. Um, and so we'll in a lot of cases send this over to them and say, look, you're beyond the scope of tort law, and this is not something that's covered by professional liability. Let's tweak the language a little bit to get you what you're really looking for, which is to trigger that coverage. And then at least that way, you know that you're protected against those uninsurable claims.
And it's a good tell too, right? So if we have that conversation with you, you have it with the client, we help you have that conversation with the client, and they dig their heels in and say, we don't care. We want you to be responsible for that. That's a red flag as from, I think, everyone's point of view, right? They don't understand what you do or what you're responsible for. It's not that your policy is more narrow than your responsibility. It's that they're expecting more from you than they should be, or they misunderstand your responsibility. It's a good opportunity to have a discussion, manage expectations, and understand, where you're coming from in terms of insurance coverage.
And that really isn't something that we just see exclusively on projects that have, a less sophisticated owner or an owner that maybe just doesn't understand um, the coverage. We see it. Large municipalities give us a hard time on
State
that.
agencies.
State agencies give us a hard time on it. They think they're doing right by their constituency by by broadening that level of responsibility, but all they're doing is avoiding what otherwise would be covered by the policy.
Right. So a quick example of that, I believe it's the State University Construction Fund has a responsibility for within your general liability to include contractor means and methods. Now, they don't mean you as the contractor as if they've just mistyped where they otherwise call you a consultant. They distinguish between consultant and contractor within their contracts. And so in this particular provision requiring insurance, it requires the inclusion of contractor means and methods. You have no coverage and cannot get coverage for contractor means and methods. That's not how that works. And so invariably, every time I see that contract, I identify the failure or the inability to even get that coverage. They won't budge, though. I include it there. And so, it's a problem. You don't have that coverage. You can't get that coverage, and it doesn't make sense.
Yeah, we always say we live in a world of what if. So we point out these things to you, and at the end of the day, you kind of make a business decision on your own whether or not you're okay taking the risk of potentially uninsured situations in the contract. We see all the whole gamut of these things as they come to fruition. Not all of these things are issues that we see on an everyday basis, right?
Absolutely.
But you have to know nonetheless so that you're aware and you can make those decisions on your own. Pollution liability is another one, and this is a good segue into the difference between claims made and occurrence coverage. Where a lot of times there's a misunderstanding of what your role is, what your duties, what your exposures are versus that of a contractor, and then in turn what your insurance coverage looks like, and the scope of that coverage looks like for you versus what it looks like for the contractor. And so just because a contractor can get certain types of coverage and do certain types of things doesn't mean that you can as a design professional, because your insurance program is written differently than theirs. And so there's always a little bit of a misunderstanding with that. And pollution, I think, is where we see it come up the most, because your requirements in a contract for pollution coverage are usually going to be copied right from a contractor's pollution liability coverage. And it's very, very different. Um, your pollution coverage is part of your professional liability policy. It is subject to the same terms, conditions, exclusions, coverage triggers of that policy, which is always going to be a little bit different than what they require in the contract of their contractors. So that's something we have to talk about quite a bit when we're looking at contracts. So what does that mean? What's a coverage trigger? Well, your professional liability policy is a claims made policy. Every other policy, for the most part, that you are familiar with is an occurrence-based policy form. So really what that means is, for professional liability, it's the policy that's in force at the time the claim is made against you is the policy that responds, versus a general liability policy, which would go back to the policy that was in force at the time of the occurrence or at the time of the accident, the incident, the damages, whatever it is. Um, and so it's a very different type of policy, and it's important that we know that, because for a lot of reasons, when you're changing insurance companies, when you're changing limits,
Canceling a policy.
any of those things, if you cancel your policy, just because you may have had a policy in force at the time you provided the services, if that claim comes in 5 years later and you no longer have a policy in place, well, you don't have coverage for it anymore. So important considerations.
Very important consideration. With an occurrence-based policy, if, if you knew something happened, but nothing came up, the trigger for a claim is usually the service of a suit
Mhm.
and not the way that we have it in professional liability policies, which is a demand for services or money, alleging a wrongful act on your part. So there are significant differences there. Claims made, you have to keep in place or get a tail if you're going out of business, but a tail too will end at a certain time. Pros and cons to that. One of the the best pro, I guess you could say there, is that it keeps in line with the legal limits that we see as part of claims. A lot of, you know, changes in what is considered an acceptable limit for a firm, depending on size and scope of services, et cetera. So what might have been $2 million 10 years ago is now $5 million as, a general rule for a firm of a certain size.
And we're seeing that on the contract side too.
Right.
Like a lot of your clients, you guys probably see it more than we do. Your clients that were okay with $1 million 5 years ago are asking for five, in a lot of cases, $7 and $10 million today. So
Right. So even without a contractual responsibility, though, if you worked on a project, 15 years ago and you had $1 million of coverage and someone is hurt today and brings suit, because in New York State, they have 3 years from the date of injury. If they bring suit against you today, and you didn't know about it, you had no idea about it before, they bring suit today, that's the policy in place today that's going to respond. So you have more limits when that claim comes in versus when the occurrence happened. So if I went home today and my son had a friend over and said friend, tripped over the soccer ball in the yard and broke an arm, years later can bring a suit against me. It's the policy on my homeowners that I have in place today because it's an occurrence-based policy rather than what I would have in the future. But you can't flip between the two on the same policy. You have to be very careful if you go from one form to another. The good news is in the professional liability world, really the only reputable companies write in claims made. I only know of like one or two occurrence-based forms, and they wouldn't be a form I would put anyone on,
no, and it
even
wouldn't,
small.
I don't think it would be a benefit to anybody. Being written on a claims made form, uh, to your point, is a huge benefit to the policyholder because of that retroactive coverage that you have. If you designed a school in 1943, um, in New York State especially, there's no statute of repose. So to Jen's point, somebody gets hurt on that school that you designed in 1943, they get hurt yesterday. They've got 3 years from yesterday to bring that claim against you. Um, so, the downside to a claims made policy is once you cancel the coverage no longer exists for all of that retroactivity. But uh, that claim for that school that happened in 1942 when your limits were probably 250,000, for that kid that got his finger lobbed off in the window at the school yesterday, that claim's probably not going to be 250,000. It's probably going to be in the millions, and that's why it's important to have that continuing claims made coverage. So it's a detriment in the sense that you do have to keep it going, but it's definitely a benefit for the retroactive coverage.
So the other part of a claims made policy is that there's a continuous application process. So with occurrence-based policies, they may call and ask for an update on something like, hey, did you put in a pool? Did you update your roof? That kind of thing. But they're not going to ask for a totally new application for you and the services that you provide. And with professional liability policies, they often do every year. There are some that will do 2 or 3, but they often ask for information updates every single year. And every single year, that application becomes part of the policy. It's a warranty. You're saying, I believe these things to be true. These are true statements. This is, there is no misrepresentation. I'm not lying on this application. These are the services I provide. And we have a very lengthy application. It's 14 pages long. We don't ask you to do all 14 pages every year. That information is input from the year before. We ask you to review it and make updates. There's a reason why we do that. We don't use the short form renewal apps, which are only a couple of pages, because we want to understand and make sure whatever warranty statement is going into that policy is as true and complete as it can be. We want you to take advantage of every opportunity for a credit. We don't want to limit ourselves from, going to other carriers and getting other numbers, and we want them to have the full scope of what you do. But it's very, very important to understand that there's a reliance on that application and the truthfulness within it. So unfortunately, we have seen situations where another unscrupulous broker would come in and will adjust information to give a lower rate or change services or move things around. And it's important to recognize that should something happen that identifies that that was a misstatement, that could be trouble for coverage. So it is a warranty within the policy.
Yep.
All right, that's it. Bye.
A couple of things we didn't talk about, we didn't really address the
Other lines of
the other
business.
lines of coverage that a standard design firm might have. Obviously, you guys probably are familiar with these things, your general liability, property, auto, workers' comp, disability. We talked about pollution a little bit being part of your professional liability policy. Um, some emerging things like cyber risks, cyber liability. I know a handful that I can just see on the call here have these coverages in place already, and that's great. We're seeing a huge uptick in those claims, which is not great, but coverage is still very affordable. If that's not something you have and you're interested, please let us know. We think especially in the coming months, it's going to be even that much more important.
If you're a firm that is expanding, acquiring other firms, a lot of mergers and acquisitions, you want to consider directors and officers. It's usually folks who don't like change will sometimes, throw up a flag in its directors and officers coverage that would apply to that. There are crime policies and employment dishonesty, which you have some on a business owner's policy. There's a million different types of coverage
Yep.
that a firm could have, and it's all dependent upon both your contractual responsibilities. So often, the policies you have in place, the program you have is determined by your contractual obligations. But I will point out with cyber liability, especially, there is often a provision within a contract that requires responsibility for data leaks and confidentiality, notification if there is a data breach, that kind of stuff.
Mhm.
That's only covered under a cyber liability policy, well, a good cyber liability policy. There are lots of them out there, but that's your best place for those kinds of coverage. So even if it's not in the list of required insurance for a particular contract, you may have a real exposure, not only to cyber liability, but to other lines of
Tied into
coverage.
confidentiality
Yep.
sections and separate confidentiality agreements. You have a responsibility to safeguard the data that's being transmitted between parties, and in some cases, you have a responsibility to safeguard the platform if that's part of your duties also, and so that can only be done by cyber coverage. Unfortunately, we just had a claim recently for a firm whose CFO was stealing money from them.
A
Uh,
significant
a
amount.
significant amount of money, and unfortunately, that firm did not have the proper coverage in place because the person who made the decisions to purchase the coverage was also the person that was stealing from the firm. So, these are not things that happen regularly, and we
Thank
do
God.
see all sides of it. But if there is coverage that you're interested in, concerned about, would like to talk more about, you can have those conversations with us without having it be a hard sell. We'll tell you all the ins and outs and whether or not we think it's something that's relevant for you, and what the cost associated with that might be. Employment practices, D&O, cyber, probably the biggest ones that we see kind of linger out there. But with that, it doesn't look like there's any other questions in the Q&A. Thanks for joining us on our first live webinar. We will be doing this on a monthly basis and try and shoot for probably the second or the third or fourth Thursday of every month. So keep your eye out for invitations. The next one we do is going to be part 2 of this, which is a little bit deeper dive into contractual
Yay.
provisions and contract
Yes.
language, and real exciting stuff. But we are open to suggestions. Anything you would like us to talk about, we can certainly put together a program, and
Absolutely.
we're happy to do it. So again, thanks for joining us, and we'll conclude with that. If you would like a certificate, I see I've got a request for one already. Please feel free to reach out.
Thank
Thanks
you.
again.
Bye.
See if we can figure out how to do this. And there we go. All right, bye.